Hello and welcome back to this series of lectures. In the previous unit, we learned as to how to conduct an inquiry. In this video, we will learn the ingredients of the inquiry report that is submitted by the inquiry officer. We will also learn in the later part of this video that on receipt of the inquiry officer's report by the discipline authority, what action the discipline authority has to take. Now coming first to the ingredients of the inquiry officer report, the relevant rule is Rule 14, Sub-Rule 23 of the CCA Rules 1965. The rule stipulates that after the inquiry, a report will be prepared which shall contain the following. Number 1, the articles of the charge and the statement of the imputation of misconduct or misbehavior. Second is the defense of the government servant in respect of each article of charge. The third, very important, the assessment of the evidence in respect of each article of charge. And the fourth one, the findings on each article of charge and the reasons therefore. Now the third part of the report is the most important part, where the inquiry officer appraise or evaluate each one of the documentary and oral evidence produced during the inquiry and brings out as to how and why the facts comprising of the charge sheets are getting proved or not proved on the basis of this evidence. The fourth part of the report is where the inquiry officer should clearly mention the findings on each article of charge with reasons. Thus, if there are 4 articles of charge, then for each one of them, the inquiry officer should specifically mention whether that particular article is proved or not proved. The report of the inquiry officer has to be based on the evidences adduced during the inquiry, which we learned in Article 311 also. And anything happening before or after the inquiry has no relevance. Inquiry officer should ensure that no part of evidence which the accused government servant was not given an opportunity to refute or explain or rebut has been relied on against him. The report must be based on legal evidence and not irrelevant consideration, conjectures, surmises or suspicion, however strong that may be. Now, the report of the inquiry officer is the basic document on the basis of which the discipline authority will form the final opinion. However, merely based on the inquiry officer report, the discipline authority cannot take a final view of the matter. This is because the discipline authority has to form an independent opinion as to whether the charges are proved or not proved based on the evidences produced in the inquiry. He is not bound by the inquiry officer's report. And it is not possible to form an independent opinion merely based on the report unless all other records in original of the inquiry are also available to the discipline authority. The other records of the inquiry, such as the daily order sheet, deposition of the witness, etc., are essential documents without which an independent examination or evaluation by the discipline authority is not possible. And therefore, the Rule 14 Sub-Rule 23 2I stipulate that the inquiring authority shall forward to the discipline authority the records of the inquiry, which shall include first the report prepared by it under clause 1, on which we have talked just now. But kindly see the other documents which have to be forwarded. The written statement of defense, if any, submitted by the government servant. Third, the oral and the documentary evidence produced in the course of the inquiry. Now, this would include the oral testimony of the witness examined during the inquiry on behalf of the prosecution as well as the defense. This would contain everything the witness said in the examination in chief, during the cross-examination and re-examination, and is the primary source for the analysis or appraisal of the oral evidences. Fourth thing that should be forwarded is the written brief, if any, filed by the presenting officer or the government servant or both during the inquiry. And lastly, the orders, if any, made by the discipline authority and the inquiring authority in regard to the inquiry. This would contain generally the orders issued by the inquiry officer during the course of the inquiry, such as postponement of the inquiry on the request of the discipline or the charge employee, etc. Now, once the inquiry officer submits his report, he becomes officio functus, and that means that the mandate of the inquiry officer expires on his submission of the report to the discipline authority, and he cannot in any manner modify or change his report or amend his report or recall his report. On receipt of the inquiry officer's report, the first thing that the discipline authority should ensure is whether the report has all the necessary documents, folders, as we discussed in Rule 23, Sub-Rule 14. Now, after having satisfied that the report contains all the documents, the discipline authority should now examine the report to check whether the correct procedure has been followed or not while holding the inquiry. If the procedure as laid down in the rules and regulation of the organization has not been followed and it has resulted in violation of the constitutional or the statutory provision or in the failure of justice, then the discipline authority should check whether another inquiry should be held. Now, the most practical way to find out this is to peruse the daily order sheet along with the various representation, if any, submitted by the charge officer during the course of the inquiry. Now, please recall the discussion of the previous video and try to recall some of the important steps of the inquiry, which if not followed could vitiate the inquiry. I will give you some illustration. Now, whether any representation submitted by the employee alleging bias against the inquiry officer was properly dealt or not. This is first immediately should be checked by the discipline authority. Another question, whether some evidence against the charge employee was collected without giving him the opportunity to defend himself. Whether the employee was denied adequate opportunity to cross-examine a witness. Whether all the defense documents held relevant by the inquiry officer were made available during the inquiry to the employee. So these are some of the things should be checked by the discipline authority immediately on receipt of the report. Take another example. Whether any new evidence was allowed by the inquiry officer. If so, whether 3 clear days were given to the other party, because that is the requirement of the rule. If not done, it could vitiate the inquiry. Take another very important thing. Whether the general examination of the employee by the inquiry officer under Rule 14, Sub-Rule 18, that is the circumstances going against the employee, were informed by the inquiry officer to the charge employee or not. Please remember, we discussed this point at some length in the previous video and we learned that non-observance of this step could vitiate the inquiry. There are many other instances I can share with you where non-observance of the steps of the inquiry could vitiate the inquiry. If the procedure has not been followed, which resulted in violation of statutory rules or failure of justice, the discipline authority, after recording the reasons, can remit the case back to the inquiry officer or any other authority for further inquiry and report. That is permissible under Rule 15 of the CCCC rules. The sub-rule 1 of the Rule 15 is displayed on the screen. Please pause the video and read the rule carefully before moving forward. It is always appropriate that the order of this remission be in a written order. The order should specifically mention 1, the defect or the irregularity, and 2, stage from which further inquiry may be undertaken by the inquiry officer. Now, if the irregularity had crept, let us say from the very beginning, that is, let us say allegation of bias representation was made by the charge employee but proper action was not taken, then a de novo inquiry can also be held if the discipline authority is of the opinion that not changing the inquiry officer resulted in prejudicially affected the case of the employee. So a de novo order can also be done. Please note that the power of remitting back for further inquiry, which we discussed, can be exercised only if the inquiry has not been properly done. In other words, what I mean to say is, if the inquiry was properly done, then the disciplinary authority cannot remit the case for further inquiry just because he is not satisfied or disagrees, let us say, with the findings of the inquiry officer. That alone cannot be ground for remitting it further. Now, this issue is well settled by a number of judgments of the Supreme Court, but I will share with you a very interesting case of Krdave versus Collector of Central Excise, AIR 1971, which was a judgment of a 5-judge bench, constitutional bench of 5 judges, where the collector, who was the disciplinary authority, ordered a re-inquiry on receipt of the inquiry officer's report. The issue before the Supreme Court was whether a re-inquiry can be ordered under the CCA rules. Now, the Supreme Court's observation under para 13, as you can see, I will read it out to you. It seems to us that Rule 15 on the face of it really provides for one inquiry. But it may be possible if in a particular case there has been no proper inquiry because some serious defect has crept into the inquiry, or some important witnesses were not available at the time of the inquiry, or were not examined for some other reason, the disciplinary authority may ask the inquiry officer to record further evidence. Now note what the court says, but there is no provision in Rule 15 for completely setting aside previous inquiries on the ground that the report of the inquiry officer or officers does not appeal to the disciplinary authority. The disciplinary authority has enough powers to reconsider the evidence itself and come to its own conclusion under Rule 9. Now, there are some other very interesting facts of the case. I would request all the readers to definitely read this judgment. There are very interesting things you will find in this judgment. Now, so far we have discussed the steps involved if the disciplinary authority finds that the procedure for holding the inquiry has not been followed. Now, in the next part of this video, we will learn what action is to be taken by the disciplinary authority when the procedure has been followed by the inquiry officer while conducting his report.